Mr. Johnson or Mr. Godfrey here? Well, then I'm not sure we have to address the request for photography. Does that work for you guys? For council? Okay.
All right, I suppose if he appears, maybe we'll
have
stop
to
and make sure we know what's going on.
say something.
But probably fine.
Just what? Yeah, I mean, the notice
notice
says
for
9:30, so
Yeah.
it's now 10:10. The next case that we will, in which we'll hear arguments is Carroll versus Clyne. You were here when I noticed, or when I mentioned about the clock and about speaking into the podium and entering your appearance when you take the podium. That just is helpful to all thousands of our listeners on the outside. 5 minutes for rebuttal is reserved. Begin anytime. Thank you.
May it please the court, my name is Aaron Harris, and along with Mr. Bayer, council table, we represent the appellant Danny Clyne. Ms. Clyne has appealed the trial court's decision to enter a permanent stalking injunction against her based on Mr. Carroll's response to 2 Facebook posts that Ms. Clyne authored in January and March of 2019.
I'd appreciate the answer to what may sound like a very silly factual question to you.
Yeah.
But for people who use Facebook, are their posts limited to the people that they've agreed to share posts with, or are they posted for the entire universe to see?
I believe there are 2 separate types. I don't use Facebook, so I may be as ignorant as Your Honor. But it's my understanding that in this case, the posts were public, meaning if somebody sought out Ms. Clyne's Facebook page and sought to find her posts, they would be able to do so.
And could pass them on, I take it.
I assume that's the case in some sense. Mr. Carroll was not a Facebook friend and was able to find them, so I assume that's the case. I don't know how fungible or how transferable they are upon finding, but you could take a screenshot of it.
I'm just trying to figure out how public they really are.
I think, well,
And maybe it doesn't matter, but I'm
no,
just...
and that's, yeah, they are public to the extent that if you went looking for them, you could certainly find them without restriction.
All right. Then there was also some allusion in the testimony, although I'm not sure how reliable this is, that the first post was removed almost immediately, and the second post was up for several days.
I believe that's the case.
But again, there's not really any direct testimony on this from anybody with sort of
Right, and again,
reliable knowledge.
Right, and again, I don't believe that that's a material fact to the determination, at least to the extent that we've appealed. The trial judge did make the ruling that the timing of the posts and how open they were was not relevant, and we did not appeal that piece.
Okay.
So the timing and how long they were available for the public to see was not a basis on which we've made an appeal.
Okay, thank you.
Yes. Obviously, if Your Honor thinks it is dispositive, I'm happy to answer questions about that. But
No, some of it's just satisfying my
Okay.
natural curiosity.
great. So Ms. Clyne has appealed the trial court's interpretation. Well, there's 3 bases for appeal. 1, the trial court's interpretation of the emotional distress standard and its application of that standard. 2, the trial court's decision despite the clear weight of a very, very light record. And 3, the constitutionality of the statute itself. Before I get to the legal aspects of these arguments, I do want to make it very clear about some undisputed facts on the record. First, Ms. Clyne herself never directly contacted anyone at ABC4.
But she urged the whole world to do it.
The whole world of people who look for her Facebook posts, yes. I'm not sure how many people are in that world, but yes. She urged those who are interested in her comments to do something about the fact that he was an ABC4 player. Mr. Carroll presented no admissible evidence that anyone that saw Ms. Clyne's post actually contacted ABC4.
Would he have had to, though? Isn't it enough for him to testify, quote, it made it very difficult work-wise, and not only work environment, but just in general my life?
No, because very difficult is not emotional distress under the definition. That's the first issue. And I would point the panel to the Aposhin case, I believe that's how you pronounce it, that's cited in our briefing. And in that case, it specifically says often, and what the court will not allow the stalking injunction to do, is allow sensitive petitioners or paranoid petitioners to utilize that subjective viewpoint to secure a stalking injunction. And in this case, Mr. Carroll's concern about his employment, I don't mean to sound uncouth, but borders on that paranoia. There was never any evidence presented that anyone at ABC4 ever saw any of the posts. At some point during some aspect of early 2019, he was renegotiating a contract. There was no evidence that any aspect of Ms. Clyne's post or any boycott that was spurred by Ms. Clyne's post had any impact on that.
But don't we look more closely at her intent, right? She had to write something that she knew or would have known would cause a reasonable person to experience emotional distress. And obviously, I assume when she wrote these posts, she thought someone would contact ABC. I mean, her whole purpose seems to be that she wants to cause some trouble here, right? So even if she's ultimately unsuccessful, aren't we looking into whether or not she knows or should have known that encouraging others to reach out to someone's employer and to express negative thoughts about him would cause someone emotional distress? And I'll reserve for that argument the idea that we can argue about what level emotional distress is. But just, I mean, it's more about that, isn't it, what she's thinking when she sends this, as opposed to whether or not it ultimately reached ABC.
Well, I will note that the record includes no evidence of Ms. Clyne's intent whatsoever, other than the words on the page.
But we discern intent all the time.
Sure.
Right.
So what that would require is for the trial court to make that inferential ruling. The trial court never did so. What the trial court said is a reasonable person would suffer emotional distress under any circumstances when anybody contacted or made any communication regarding an employer.
Well, I think he actually was a little more I mean, he said the difference here in this case was not that just she was contacting an employer, but that she was encouraging a host of people to contact the employer. Isn't that the difference the court recognized in this case, was that it wasn't just her saying, hey, ABC, this guy's a bad guy. It was her encouraging others to reach out.
Correct, just as any boycott does. And this gets to the constitutionality.
Sure.
Where we believe that it's supremely overbroad because it would potentially enclose a great deal of otherwise protected speech into a stalking injunction statute.
Do we need to reach that argument if you win on that?
Well, I don't believe that you do. Certainly, we're happy with the win however we get it. I don't believe that it's a constitutionality argument solely that would vacate the stalking injunction. The briefing is very clear that the weight of the record, as well as what the trial court utilized as the emotional distress standard, both of those were in error. And if the court were to decide that, then the stalking injunction would be vacated and the constitutionality question would not have to be reached. However, to the extent that the court says, this court says that the trial court utilized the appropriate emotional distress standard as stated in the statute and as interpreted by Baird v. Baird and Aposhin, then our position would be that it is overly broad and that utilizing the statute as stated in the case law and in the statutory language over-includes a great deal of constitutionally protected speech. But I don't think you have to get there in order to vacate this because of the trial court's use of the wrong emotional distress standard and the clear weight of the record not supporting the ruling that the trial court made.
Would you agree, and I'm not sure how relevant this is, other than in Baird versus Baird, the Supreme Court seemed to lessen a little bit, if you will, the standard for emotional distress. What the Lopez standard required was outrageous and intolerable. And now we have would cause a reasonable person to suffer emotional distress.
Right, a reasonable person.
Doesn't that hurt you here in the sense of, in reviewing the conduct and the standard that the district court applied, doesn't that hurt you?
Well, it certainly is a lesser stringent standard than before. I would concede that and agree with that. I don't believe that the fact that the standard was reduced from the Lopez case puts us in the middle of it. I believe, and I think that when reading Opposition, I think it's very clear that there's a great deal of discomforting, annoying, frustrating, adversarial conduct and speech that still does not create significant mental or significant psychological suffering, which is what is required. And that's in paragraph 23 of Opposition. And I see I'm out of time almost, so I'll read that paragraph, and if there's more questions, I'm happy to answer it. I'll sit down. But paragraph 23 of Opposition states, there is nothing in the record that establishes that the trial court looked at the totality of circumstances. Oh, excuse me, I'm quoting the wrong paragraph 22 of Opposition. The second half of this paragraph states, under the standard, a court must consider the entire context surrounding the defendant's conduct. That's from Baird. And then, again, quoting Baird states, however, courts must avoid succumbing to a purely subjective analysis, which is inconsistent with the objective standards intent to protect against criminalizing conduct that only an unreasonably sensitive or paranoid victim would find harassing, so as to reduce the risk of a truly innocent defendant falling within the ambit of a stalking statute. And so, if this court has questions on that, I'll leave it there and reserve the rest of the time.
Thank you.
May it please the Court, Kyler O'Brien on behalf of appellee Adam Carroll. Your Honors, this is the application of Utah stalking injunction statute. It is brought to the modern era, and Facebook is involved, and I'd like to take a quick opportunity to discuss how that is relevant to this case. When we think of stalking, we imagine a man in a mask hiding between a bush and a wall, looking into a window, trying to identify the victim of his alleged stalking. That is what we see in film and media. It is replicated in our imaginations when we hear the word stalking. It is fundamentally uninclusive and under-inclusive of what is intended by the Utah legislature to amount to stalking. And I'd like to discuss all of that in turn. Utah defines stalking as a course of conduct designed to cause a reasonable person to suffer emotional distress. The emotional distress is further defined as significant psychological or mental suffering.
But your client testified only that it made it very difficult work-wise, and not only work environment, but just in general my life. Does that sound like significant emotional harm?
Yes, Your Honor. There is case law. Had this come to the court in a vacuum, then perhaps we would not have any case law to pull from. But this court on 2 occasions has discussed the emotional distress standard at length. In Baird, the court set forth a series of factors that a trial court should consider when weighing that particular issue. Among those was whether or not a purported stalker had knowledge of a victim's vulnerability and whether they acted with knowledge of that vulnerability. The court indicated that trial courts should look into the victim's background, that they should look for abuse between the parties, that they should look for the location of the stalking, how the method of the stalking.
But there was almost no testimony about any of that.
The trial court specifically found that, in this case, the victim had knowledge of particular vulnerabilities. The trial court heard evidence of 2, and the posts relate to 1. The vulnerabilities are, number 1, that Mr. Carroll was involved in an ongoing divorce action, that Ms. Clyne sought to insert herself into that action and sought to influence employment decisions on the basis of those proceedings. Not only did Ms. Clyne attempt to introduce bias on the basis of those proceedings, she sought third parties to engage in that conduct which, once she had sought their involvement...
Did you say she stalked third parties?
Sought third party
Sought.
involvement. Apologize, Your Honor. She sought third party involvement online in a public forum, which was easily and publicly accessible, which my client found despite the fact that he was not friends. Now, this There was no testimony as to that, but a reasonable inference was that he either stumbled across a random page or that third parties informed him of it. Regardless, it is very much obvious that these publications were in the open. There are direct communications in the posts that are preserved in the record that Ms. Clyne sought that third parties directly share the information. She rewarded third parties upon their dissemination of the information with praise, and she specifically requested that they seek others to contact his employer. The district court noted the invidious nature of this particular request, stating that once she had involved third parties, she had to some extent lost control over their conduct that she had initiated and was to some extent responsible for.
Can I ask a question about that in the sense of Bear does acknowledge that the particular vulnerability of the victim needs to be taken into account in determining whether there was emotional distress. But isn't one of the particular vulnerabilities of Mr. Carroll the fact that he's a public person? What would be the difference of somebody posting on their Facebook page that I am a terrible judge and that I should be not retained? Could I go and get a stalking injunction in favor of that, against that person?
I don't believe so, Your Honor. And
That would cause me certainly emotional distress.
Yes, Your Honor. And I'd like to address that hypothetical for a moment. In your scenario, a few things are happening simultaneously. Number one, you are a public figure. Mr. Carroll conceded in hearing that he was not a public figure within the judicially understood notion of the term.
But he refers to himself as a public figure.
He did, but without any of the underpinning understanding of the jurisprudential philosophies of that phrase.
Well, we don't necessarily know that. I mean, much of this really, frankly, sounds like a defamation action, except he doesn't qualify because he's a public figure.
Well, Your Honor, Ms. Clyne has also argued that he is not a public figure, and that was conceded at the trial court level. So I believe from a procedural standpoint, there is no argument that he is a public figure. I would argue from the context of those statements, he was positioning himself as a public-facing figure, a figure whose clientele is the public, a person who sees him as a meteorologist, whose reputation is premised upon the fact that he provides a skill set to the public, which is a slightly different conceptualization of that phrase, that he faces the public. And Judge Forster, to answer your hypothetical, in that context, the comments made would have been of public concern. Your retention, why I hope continues decades to come.
Thank you.
It relates to your employment. It relates to the performance of your employment. In the hypothetical you raised, if the individual in question had raised legitimate facts as to how you would handle the case, regardless of as to whether or not they would in fact hinder your retention, they are discussing their viewpoints on a political issue. These posts on Facebook related to matters of a personal nature, which, going back to Baird, is an additional factor this court can consider, whether the victim had knowledge of or a relationship to the defendant. In this case, we see that the defendant mentioned not only my client and ABC4 News, but they also mentioned his minor child. They indicated that he was attempting to plan and plot to dump her and to take her child. These words are words which are ambiguous and intentionally so. They are intended to elicit a response by third parties, an emotional response, and they did. In the evidence preserved in the record, we see pages of comments that Ms. Clyne responded to. This wasn't simply two Facebook posts encouraging people to take retributive action against a weatherman because he's failed to accurately predict a snowstorm. This is a case where we have an individual with uniquely personal knowledge. This is not only my client, but his minor child. This is not only my client, but this individual had knowledge of my client's relationships, discussed those relationships on this forum, discussed why those relationships were relevant to his firing. These are intimate and personal issues that have been put out on a public forum with the intention of having an employer retribute against an employee, not because of performance of their employment.
But I'm still hung up on the fact that he never testified to the emotional impact that this was having on him or whatever suffering it was causing.
Your Honor, on page 96 of the record, Mr. Carroll testifies as to three things. He testifies that he feared a loss of employment and the implications this would have on his ability to provide for his minor child. Both in Baird and again in State v. Miller, this court discussed how threats of loss of employment were particularly invidious and were particularly subject to cause emotional distress. Specifically, I'd like to raise two points discussed by the court in Baird and then by the court in Miller. In Baird, the court hypothesized that an individual could send a dozen roses, and in one context it would very much seem to be a casual observation with no particular implications for wrongdoing, and in another context could be absolute and dispositive evidence of stalking. And the relevant piece of information, the relevant logical piece to pull from that statement is that we are looking to the entire context. Mr. Carroll didn't use the words in his testimony, I was caused significant mental or psychological.
No, but see, at least when I was a trial court judge, testimony like this, where talking about how the post might affect his employment, would also be accompanied by testimony such as, I couldn't sleep. It made me sick to my stomach. Every time I saw this woman's new posts, I trembled. There's some sort of additional manifestation other than it made it very difficult work-wise.
Your Honor, my client could, and I would direct the court to page 96 of the record specifically. I think that is helpful in explaining this. He discussed that he feared a public backlash due to his custody award, that they had discussed his custody award in the public posts, and there were numerous reasons why that was causing him anxiety. Page 96 of the record does help explain my client's mental suffering, the basis for that suffering. He was unrepresented. Had counsel been there, they could have elicited some additional conversation.
But we don't treat this case differently because of that.
Yes, Your Honor, and I would not argue that you should. I think, though, when we are looking at pro se litigants, it's important to identify their natural use of language. And here, Mr. Carroll used his words advisedly and cautiously. He used them meaningfully. He said that he noted he had fears that were specifically tied to his public-facing position, to his backlash on custody, that he had failed to provide his child with child support, despite the fact, and he testified to this in hearing, that he was not ordered to pay child support because he had primary custody. So he's being perceived as a parent who is not meeting his financial
And I
obligations.
don't have the transcript in front of me, and I didn't write down the record number. I wrote down the page numbers for the transcript. But does he use the word fear? I'm just trying to tell whether those are your words or his words.
I believe he does, Your Honor, if I may have a moment.
Well, it's okay. So I'll include it in.
On page 96 of the record, he specifically says, in response to a discussion as to the comments made in the Facebook post, and for these comments to be said, and then to have her tell everyone, to tell the world, including try to contact my station to inform them that she was spreading rumors or lies, that that there may not have been correct. Like I said, whether you want to call it hearsay or not, during the contract negotiation that could have been or not have ended with me being unemployed, and I am currently the person providing for my son. For her further down it says for visitation rights, it would have had a major impact of my life. He further goes on, he said, I've had a very crazy week.
That's kind of more descriptive of what she's doing and the consequences it could have, rather than his testimony about the effect it was having on him in the present.
Yes, Your Honor, and in prior case law, when discussing the closing clause of the emotional distress definition section, it states whether or not medical or other professional treatment or counseling is required. And in discussing the public policy behind that, we don't want victims to have to go through the re-victimization. We want victims to describe the events that occurred. And the court, the reason the material term is intent in this, was it the intent of the purportment to cause emotional distress?
Well, and I think, if we look at Baird, it talks about how the subjective effect on the respondent's conduct on the petitioner is irrelevant. It's a solely objective standard. So I think that's why the court looks at the circumstances and then decides whether a reasonable person would experience distress.
Thank you.
Is that fair?
That is your honor.
Let me ask you a question about, I think, what ends up getting to a constitutional issue. When you were, addressing Judge Forrester's question about people commenting about her work as a judge, and if they commented negatively, it would affect her, cause her significant emotional suffering, right?
Yes, Your Honor.
But you said, no, she wouldn't be entitled to a stalking injunction in that instance.
Yes.
But would you agree that the statute would cover that? I mean, is there something in the way the statute's worded that would exclude that, or is it just that you're saying that would violate the Constitution if one were awarded under those circumstances?
No, I think that when we're looking at course of conduct, when we are looking at emotional distress, the context of that is that it would cause a reasonable person emotional distress.
And we know that if someone posts negatively about us on whatever blog, it would cause us emotional distress. I think they would say a reasonable person would experience emotional distress. It affects their job, it affects their livelihood. It would cause them emotional distress. So then wouldn't that conduct fall within the stalking statute?
I think that when the court is looking at the entire context and whether the intent was to cause significant emotional distress, I think in the hypothetical posed, I don't think the intent was to cause emotional distress. The intent was to criticize a public figure for the method in which they resolved a specific case. The intent was to create a more effective judicial process or remove a judicial figure who the reportant felt was not fully exercising their oath or was failing to uphold the Constitution.
But I'm just going to stop you for a second, because the statute says a person's guilty of stalking who intentionally or knowingly engages in a course of conduct directed at a person and knows or should know the course of conduct will cause a reasonable person to suffer emotional distress.
Yes, Your Honor.
So it seems to be worded in a way where you intend to engage in the course of conduct knowing it's going to cause distress. So you may have a very legitimate reason to do it, right? And in that sense, the Constitution might protect it. But I think that gets to the constitutional argument, right? Is that doesn't that course of conduct fall within the statute on its face?
Your Honor, I believe, I am out of time. May I answer your
Yes.
question? I believe it would fall within the course of conduct because that looks simply to the actions taken.
Right.
I don't believe it would necessarily fall within the intent to cause emotional harm. I think that
But does the statute require intent to cause emotional harm or just knowledge that emotional harm will result?
it would be our position today, Your Honor, but it requires intent to cause emotional harm. And I know my time is up. I failed to address it is our position that the constitutional issues have not been preserved. I would simply note, court's allowance, that if you look at the record, the word constitutional appears, I believe, twice. There was no legal authority. The appellant's position in their reply is that it would be, that is in essence that we should create an exception to the preservation rule because it would be impractical in proceedings such as this where a respondent has no right to file a written response to ex parte proceedings. Number one, that misconstrues the proceedings. A respondent has no right prior to the court's order on the ex parte application. However, a respondent absolutely has a right under the Constitution due process requirements to file a written response, to raise legal arguments. Ms. Clyne, at all times after the entry of the temporary ex parte stalking injunction, had the authority to seek, or to file, a written memorandum of law and points of authority. She elected not to do so. In hearing this, the counsel for appellant specifically noted that the Baird versus Baird case, using it to discuss the emotional distress standard. Now, it is relevant to note that Baird does not include any reference to the constitutional arguments, and that there was no other case law provided. So even if this court felt that the nature of the proceedings warrant a re-evaluation of the preservation rule, which we believe it does not, it would be our position today that there was another method by which the appellant could have preserved her constitutional arguments and failed to do so. If there are no other questions,
Thank you, Mr. O'Brien.
thank you.
Aaron Harris again, for the record. Very briefly on preservation, I would just refer the court to the case that we cited in our reply, brief through the Utah Department of Transportation. the essence of the preservation rule is that in order for an issue to be preserved, the district court must be given an opportunity to rule. Mr. Thayer, his counsel at the hearing, raised the argument 2 separate times, one after the directed verdict motion, before putting on his client's defense case. That certainly put it squarely in front of the court, gave the court the opportunity to rule on it.
What was the unconstitutional argument specifically? What was the one that was made? Because I know he just kind of threw out free speech and threw out unconstitutional, but what specifically was he asking the court to decide?
Well, the word vague was used twice. However, the argument, while the word vague was used, the argument more of an overbroad argument, saying, I don't know what isn't included in this. If you're going to include these types of things, then you're going to include all sorts of things. So the word overbroad was not used, but the argument was more of an overbroadness argument than it was a vagueness argument. Although the Bushko case specifically says if somebody can't figure out what is and isn't covered by a statute, that's vague. And frankly, I'm not sure that an ordinary person would look at the stalking statute and think, if I send 2 Facebook posts out to my friends, I'm now stalking someone that I didn't even address this communication to. I do think it's also unconstitutional for that reason. But I think that the argument that was made in the trial court was more of an overbroad argument, which is the Relaford case, which we cited. And I do note, despite it being in our opening brief, that was never even touched, analyzed, addressed at all in the appellee's brief. And it's an interesting bellwether case. It addresses the exact same language to or about a person in a stalking statute. That case was an interesting case. An individual sent some emails to an employer apologizing and then saying, well, I just want to look for some employment, and then on some Facebook posts made some very vulgar, crude, certainly very uncouth statements about this individual who was considered the victim, sentenced to 6 years in jail for these. The Supreme Court of Illinois said that's not going to happen. There's nowhere that is a constitutional phrase, and we've got to take it. I would encourage the court to read that case if the court has not yet. It is directly on point. While it doesn't create any specific precedent this court has to follow, it is very compelling. And the analysis in that case is one that I would follow, and one that we did follow in the briefing. And if I had more time today, I would walk the court through it. But in specific response to some issues raised by my colleague in his oral argument, that the issue with vulnerability, it is undisputed that Ms. Clyne had no idea that Mr. Carroll was going through these contract negotiations. And it's based on these contract negotiations that he claims the emotional distress was at its peak. If she doesn't know about the contract negotiations.
But you say that's undisputed. I don't recall testimony about that in front of the court.
Or that's my point. There's no evidence that she knew.
Okay, but that doesn't mean it's undisputed.
Well, he didn't make an allegation that she did anywhere on the record. And she was never asked whether she did or did not. So there is no fact on the record that supports that she had not. And so given the fact that the plaintiff has the burden, the plaintiff cannot utilize an inference, an implication, or make an argument that that's a vulnerability to be considered because there's no evidence that she knew about it.
It's a lack of proof as opposed to really
Sure.
being undisputed
But
fact.
in this setting, that lack of proof is she didn't know. Because you have to prove that she knew, one way or the other. He could have called her to the stand and asked. He didn't. So it's undisputed in that sense, that there is no evidence on the record that she knew. So that vulnerability is not one that can be considered or is relevant in any way, shape, or form. With respect to, I think it's a very fine distinction without a difference that the appellee is attempting to make with this public figure argument. He is a figure in the public. I can't remember the exact terms used in the argument here today, but he utilized his public figure status as the basis for his fear that people would now pile on to ABC4 because they knew about him and they would be upset. He can't utilize his public figure status as a catalyst for his fear, as a catalyst for attempting to meet the standard, and then at the same time say, well, I'm not a public figure. I think that Judge Appleby's comment that this seems like a defamation case that he can't pursue is directly on point. And while I use the word fear, I should not have, because neither fear nor afraid appear anywhere in the record. I checked the index, over there, they're not there. So whatever his emotional response was, based on his public figure, his self-proclaimed public figure status, he certainly did not say it was fear, and he certainly did not say he was afraid. I want to very briefly discuss some of these examples that came up. What if, me as an attorney, I represent people, maybe a client is unhappy with my representation. I'm not a public figure. If that client says on Facebook 2 different times, nobody hire Harris, he's a hack, I can't, that's not, no matter what emotional response I have, that's not going to create what under the statute should be the severe psychological distress or the severe mental distress that is required to create the objective emotional distress that has to trigger this.
Isn't that then the critical difference between the facts of this case and those hypotheticals, is that in addition to any effect on Mr. Carroll's job possibilities or contract negotiations, there was language in those posts directed at his personal life. Isn't that a distinction that's relevant here?
I don't believe it is. If somebody said Harris is a horrible husband, he beats his wife and he beats his kids, don't hire him, I would have a defamation claim, certainly. But I can't imagine that that creates the basis for a stalking injunction. If the individual were targeting my house or targeting me with emails saying, you're a horrible husband, I'm going to come make you pay for it, that's different. But to just tell the world things about me and create a basis for me to, on 2 occasions now, say, well, I'm being stalked, I think that is far over what the Constitution would allow. The Constitution, I won't say unfortunately, but when we're dealing with statutes like this, it makes it very difficult for the statutes to toe the line. That's the point of the unfortunate. It's difficult to craft a statute that doesn't cross this First Amendment line, and that's what the Relaford case recognizes. And in paragraph 47 of the Relaford cases, while it's the only case that deals with the stalking injunction, it cites to other cases that dealt with online bullying and online harassment statutes that also, despite their specific purpose to protect children, also were far too overbroad because it just enveloped too much protected speech. Unless the court has questions, I'll leave it there.
Thank you, Mr. Harris. Thank you, Mr. O'Brien. We will take this matter under advisement and render a written decision as soon as possible, as soon as we can.